Good day everyone, I am Federico Yorong Jr. of BS Criminology. So for today's video, I'll be citing here what are my understanding regarding Rule 112 of the Revised Rules on Criminal Procedure. Wherein we say, Revised Rules on Criminal Procedure, these are the rules, the steps or the procedure needed in investigating crimes. So to start with, under Rule 112 is the preliminary investigation. When we say preliminary investigation, it is the initial response to any report of criminal activity, including both accidental and intentional. It is a vital part of the total investigation process. It must be performed to determine if there is a need for a full investigation, formal occasion, and trial, because the main purpose of a preliminary investigation is to determine whether a crime has been committed. In Rule 112, it consists of 9 sections. Those are preliminary investigation for Section 1, officers authorized to conduct preliminary investigation. For Section 2, procedure. For Section 3, resolution of investigating prosecutor in its review. For Section 4, resolution of investigating judge in its review. For Section 5, when warrant of arrest may issue. For Section 6, when accused lawfully arrested without warrant. For Section 7, records. For Section 8. And lastly, is cases not required for preliminary investigation nor covered by the rule summary procedure. Section 2 of Rule 112. Under Section 2 of 112 states that the other officers authorized to conduct preliminary investigation, meaning to say there are only people who are allowed to nor authorized to conduct a preliminary investigation, and those are A. Provincial or city prosecutors and their assistants. B. Judges of the municipal trial courts and municipal circuit trial courts. C. National and regional state prosecutors. And D. Other officers as may be authorized by law. Section 3 of Rule 112, Procedure. Under Section 3 of Rule 112 is the procedure, meaning to say, in having preliminary investigation, there is a procedures needed in order to determine the crime case easily. The procedure will serve as a step-by-step guide in order to have a good outcome of conducting preliminary investigation. Section 4 of Rule 112, Resolution of investigating prosecutors in its review. Under Section 4 of Rule 112, it is resolution of investigating prosecutor in its review, wherein the prosecutors find cause to hold the respondent for trial, he shall prepare the resolution and information. Section 5 of Rule 112, Resolution of investigating judge and review. Under Section 5 of Rule 112 is resolution of investigating judge and review, wherein within 10 days after the preliminary investigation, if the investigating judge shall transmit the resolution of the case. Section 7 of Rule 112, when accused lawfully arrested without warrant. Under Section 7 of Rule 112 is when accused lawfully arrested without warrant, meaning to say, when a person is lawfully arrested without a warrant involving an offense which requires a preliminary investigation, the complaint or information must be filed by a prosecutor. Section 6 of Rule 112, when warrant of arrest may issue. Under Section 6 of Rule 112 is when warrant of arrest may issue. It must be within 10 days from the filing of the complaint of information for the regional trial court. While for municipal trial court, preliminary investigation is required to be conducted before filing of a complaint or information, wherein the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to fine. Wherein each sections further discuss the procedures or other necessary things needed in a preliminary investigations. Each of the sections are important in having preliminary investigation, for it helps find out nor resolve crime cases easily. It does help also in a way of having the better process of preliminary investigation. That would be all. Thank you.